the estate of Kim Garcia, or KG LLC versus the estate of Kim Garcia and all occupants. Are you living at 900?
Yeah, I am living there. Yeah.
All right, then I guess you qualify as all occupants. Even though this is the second hearing, I might as well advise you of your rights. Good afternoon, Mr. Smith.
Good afternoon, Your Honor.
You are a defendant in a landlord-tenant matter. The owner of this property wishes to take possession of the property, and they asked also to accelerate the foreclosure because the residents, whoever is in there, has refused to allow inspection of the premises. You have a right to hire an attorney. If you cannot pay for one, legal aid may be available to represent you, but we don't have court-appointed attorney in civil matters. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this appearance or make the demand in writing within 5 days and pay the $50 jury demand fee unless the judge waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that's a different circumstance. In this case, the property has been foreclosed on. The buyer simply wants to take possession of the property. In order to do that, need to get you out. You may be able to reach an agreement with the landlord through counsel, in which case we would file something of a conditional order of dismissal if the parties can agree on the terms, or the matter could possibly be referred to mediation if both parties were interested in referring the matter to mediation. Mr. Smith, Mr. Garcia was not here last week. I didn't know whether anybody was in the premises or not. Apparently he is in the premises. Mr. Garcia, who is Kim Garcia to you?
That's my mother. Yeah, she passed away last year.
Who else is in the premises?
Mainly just me. My kids are here on the weekends.
Mr. Smith, he wasn't here last week, so why don't you repeat the premises on which the plaintiff is asking here?
Sure. This is pursuant to MCL 600.3237 and 38. A notice, two notices were sent to the property back in August when the property was sold at sheriff's sale. My client was the buyer at sheriff's sale on August 28th. Mailed two notices to the property, a notice of sheriff's sale purchase, letting them know the property had been purchased at sheriff's sale, and a notice of initial inspection, both which requesting an opportunity to inspect the interior of the property on September 3rd at 10 a.m. The representative of my client appeared at that time and date, but to perform that inspection, but no one appeared in order to afford them access for that. So we brought this action seeking order of possession and early extinguishment of the redemption period that's running from August 28th.
They're asking you to move within the next 10 days. This foreclosure process takes a while. So probably after your mother died, or maybe even before, nobody made the payments on the property. It takes a long time to go into foreclosure. And for probably a year or more, nobody's paid anything. A buyer bought it at the foreclosure sale. They asked for inspection, which you apparently ignored or didn't allow. Now they want you to move out. What's your response?
I don't even know how to respond. Yeah, on the inspection date, I'm sure I was at work. I don't know what happened there. I mean, how much time you want to let me have? I have nowhere to go, so it's gonna be kind of rough.
That's the answer I often get. And I'm not being flippant. People say I'd move if I had somewhere to go, but simply ignoring everything isn't very effective either.
You're right.
This has been in the works for several years. This process is the process that landlords have to use to make somebody move. Nobody would ever move because it's hard to find a place to move to. So this broaches the issue. The sheriff comes and puts all your stuff out in the street. And they're asking me to do that 10 days from today, which would be December 11th. Mr. Smith, do you have any discretion in that matter?
I do, depending on, with some reason, depending on Mr. Garcia's flexibility at the utmost. Yeah.
All right, Mr. Garcia, can you be out by the end of the year, December 31st?
Yeah, that would be a good amount of time.
Is that acceptable
helps
to
a lot.
you?
Yes. Oh,
Yeah,
sorry.
that's acceptable to my client. In conjunction with an extinguishing of the redemption period at that time as well.
Yes. All right, you consented to move within 30 days rather than 10. We'll get you out by the end of the year, get the property to the defendant. You've agreed, you don't have a lawyer, but when you do reach an agreement like this, you have 3 business days to notify the court if you misunderstood or didn't otherwise agree to the agreement. Mr. Smith is going to send me an order that says the redemption period will be extinguished and you agree to vacate by December 31st, 2025. The appeal period is still December 11th. Now, that means you got to get your stuff out. Any instructions for the keys?
I don't even have a key for the front door. I don't even have a key for the front door. So,
All right, just lock it on your way out.
okay.
But how long have you lived there?
How long have I lived here? Quite a while. I before my mom passed, I was taking care of her full time because she was disabled. Then she passed. There was no will or anything put in the house in my name. I couldn't afford a lawyer to get that all taken care of. So I've just been kind of living here since May
Well,
of
the
last
good
year.
news is you haven't had to pay anything to live there. I'm sure you've been paying the utilities,
Yeah,
but it's a no rent situation. They're not asking at this point for any money. They're simply asking you to vacate. So,
right.
Mr. Smith, if you would send me an order, consent, the defendant agrees to vacate by December 31st. So the first day a writ could issue would be January 2nd, which would be Friday. The really first day anything would probably happen in this case would be January the 5th. But you have until December 31st to vacate, lock the doors, and leave your forwarding address in writing on the counter.
Okay.
All right, Mr. Smith, you've got our email address.
If you give it to me one more time.
It's on the notice, but it's
very good.
3bcivil
3B civil.
at
Yep.
stjosephcountymi.gov.
And on the order for defendant's signature, just simply put on the record.
Agreed on the record.
Agreed on the record. Very good.
All right, Mr. Garcia, at least I'm glad you were here. I got a little more context to what was going on here, but at this point, you need to be out by the end of the year. All right, good luck to you, sir.
Understood. Thank you.
Thank you, Your Honor.
Good afternoon.
I was looking at your Golden Ponds case, which is set for 1:30. It's filed as a good old fashioned just cause termination.
Yeah.
And I looked for 3 lates and then I realized it wasn't that, but I'm missing something.
Yeah. So we're waiting on getting some police reports. We just don't have them
You
yet.
indicate defendant has threatened safety and well-being of the park outlined in B1 and D below, and I don't have that.
I think that's from the statute. Which references, so the actual form has a reference to MCL 600.5775 subsection 2 on it. which is an explanation of just cause termination. B is failure by the tenant to comply with a lease or agreement of the park or with a rule or
Well,
regulation
is
of the
that
park.
attached somewhere? Am
Yeah,
I missing it?
I
or-
think it got missed. I think it was supposed to be attached and it didn't.
All right, well, we'll see where we go here.
Yeah, and I've also got some additional documentation I can submit to the court. I've got a couple of voicemails and some other notes. And like I said, I'm waiting on some.
We'll get to that
Police
in a
report.
minute. I would note in our first matter at 115, neither party appeared. All right, I'll call the next case. Future Investments versus Savannah Miller. File number is 252276LT. She is not here. This is filed as a termination of tenancy. They've been trying to terminate the tenancy since last August. Defendant was personally served. Mr. Cromendike, what can you tell us about this?
This was a property that my client actually purchased from Miss Miller. They agreed to allow her to stay for a certain amount of time after the sale went through. She's now overstayed that amount of time. The latest date that she could be out on, according to their agreement, was October 11th. And so that is why we're here today. We're not requesting any money, just possession of the property.
Let's see who this is. Good afternoon. Somebody's joined us by telephone. Who am I speaking with?
Richard Walters. I'm on video, but I'm not sure I'm right.
You're late for your own party, which is very
Yeah,
frustrating.
I've had it on video and it never came in, apparently.
We'll come back to you in a minute, Mr. Walters. I just wasted 15 minutes waiting for you to show up. All right, let's
Yeah,
address
fine.
this matter.
I apologize.
All right, just wait. We'll come back to it.
Yes, sir.
All right, the defendant was personally served. She is not here. Let's make sure she's not outside. Hi, looking for a Savannah Miller. Sienna Miller? All right, thanks. Right, neither one of them are here. All right, subject to default. Possession 10 days from today would be December 11th. All right, Mr. Cromendike, if you'd send me an order, I'll sign it.
All right. Are you guys on my file, Your Honor?
No, not yet.
Okay. All right.
No, we're not, ashamedly.
Okay. We'll get one in.
All right. Richard Walters versus Aaron Faith Blair. This is a property at 211 West Main Street in Sturgis. Mr. Walters, you're moving to terminate this tenancy. You want Miss Blair to move?
Yes.
There is no lease?
No, she never paid rent. My stepson lives there, and she just, after his brother passed away, she just kind of moved herself in, and without my consent or anything. And I was trying to get the stepson to get her out, and he wouldn't do it, so I had to go through the courts to try to get her out.
What's his name?
David Wolf.
Well, she's there as a lawful guest of him.
Right, but he didn't want to get her out. But I'm assuming that I have heard that she'd been arrested for drugs and possession and retail theft.
How's that relevant?
Well, I don't know. I mean, she isn't there right now.
All right, so she's not there now?
No, she is not.
Since when?
Apparently since she's been arrested, been a month or so.
Well, let me look.
Okay.
I thought you meant she got arrested and released. If she's in custody. Oh,
Yeah,
wow.
I don't know. I haven't heard.
Hi, Judge Middleton calling. Could I see Aaron Blair? All right, thanks. Bye. Yeah, she's in custody.
Oh, okay.
Sorry, we'll come back to her. If I'd been wise enough to figure that out, I would have dialed her up. But I would have let her go anyway, because you were late. All right,
Right,
well,
right.
stay with me. We'll come back to it. All right, we do have
Okay.
several tenants here. We have Ashley Suter. And we have no one here on behalf of Mr. Millerance. That's set for 1:30.
I'm here.
Oh, who's here?
Travis and Randy.
All right, Travis is with you.
Yes.
All right. All right, for those of you that are here, Ms. Suter, Mr. Millerance, and Miss Bailey, you are defendants in a landlord-tenant matter. In each case, your landlord wants to terminate your tenancy, wants you to move out. Because this is a legal action, you do have the right to hire a lawyer. If you can't afford an attorney, you could request legal aid to represent you, but we do not have court-appointed counsel in civil matters, only criminal matters. Or you could seek other legal advice. You have the right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days using the jury demand form and file it with the court and pay the $50 jury demand fee unless you have the inability to pay it, and ask the judge to waive it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, we would go in a different direction than these termination cases. You may be able to reach an agreement with the landlord by going through mediation. So far, that's never happened, but it might one day. If both parties are interested, the court can make that referral. You may be able to reach an agreement with the landlord, means the case will get dismissed, in which case the attorney or the court could assist in filing what's called a conditional order of dismissal. So our next matter, our 1:30 matter, is Golden Pond Estates versus Travis Millerance and any other occupants, which include Randy Bailey. Mr. Steve Cromendike is here for the plaintiff. I had a little trouble interpreting the pleadings, but Mr. Millerance, they want you to move and terminate your tenancy. That would give you 10 days to move out, 90 days to move or sell your mobile home. They allege some violations, but I can't yet tell what they are because the pleadings weren't very clear. Mr. Cromendike, you wish to speak to that?
Yes, we're waiting on getting some police reports pursuant to a FOIA request and are still waiting on those. And we've been waiting for quite some time. So I don't have those now. It is my understanding that the police have been at the park related to Travis's behavior a number of times recently. In addition to that, I've got a couple of notes here, and Mr. Dave Elliott is present regarding some altercations with Travis and Dave, who was doing some maintenance at the park. threatening, Travis was threatening Dave. I've also got a couple of voicemails to another park manager that were fairly threatening, and some complaints from neighbors as well.
Well, Mr. Miller, that doesn't sound very good. What's your response?
Threatening me, you mean?
Are you Travis Miller?
Yes, sir, I am.
All right, well, they want you to move out. What do you think of that?
I'm not moving out nothing. They don't have no reason to kick me out. I didn't do nothing wrong.
But I can't wash it full now. Yes.
Dave is the problem.
Times more cleaning power. Plus it contains plenty of.
You are, bud.
Okay.
There is no. There's something.
I have been in contact with Meg as well. She just isn't present today.
We have an attorney.
He is on a bench trial right now, so she's not present today.
I spoke to Meg
All
last
right,
week.
well, here's what I can tell you from my files, Mr. Cromendike. Mr. Miller was charged with domestic violence second offense in 2 file 911 SM, pled to disturbing the peace in front of Judge Patterson. Excuse me. And he hasn't paid the fine. Then in the most recent case, 251627, charged with resisting and obstructing a police officer and domestic violence from August of 25. He's on probation from Judge Patterson here at the court. That is file 251627.
They brought it.
He isn't making his payments in that either.
His probation officer told him to pay for his anger management class and everything before he started his paying on his fines.
All right, that probably makes sense. Let me get those numbers again. 251627 FY. And these are just the ones from 25. 25911 SM.
What was that second one? 25911.
SM. That was the disturbing the peace. I believe that was at the park.
Okay.
It was between me and Travis.
Yes. And I believe the other one was also at the park.
Yes, between me and Travis
right.
because my nosy neighbor.
Well, apparently they don't want you to be there anymore. They'd like you to move your trailer and go away. The law says you're entitled to have a second hearing in this matter. And you allege that you've contacted Megan Bauer. Which means we're probably going to have a hearing, but let's pick a date, Mr. Cromendike. Next Monday seems to be good. We're through the Thanksgiving holiday. And
Next
so
Monday,
that
the
would
8th.
be- Yes,
It would need to be
at-
in the afternoon for me.
2 o'clock. Does that work for you?
That will work.
Continue to December 8th. 2025 at 1 o'clock, at 2 o'clock. May
And I will-
ultimately get a hearing.
In between now and then, I will send in some of the voicemails I have and other documentation.
All right. All right, Mr. Millerans and Miss Bailey, let me
Yeah.
repeat. They want you to move. They want you to take
Right.
your trailer out of their park and leave. And if they got what they asked for, next week, I would give you 10 days from December 11th to move the trailer and 90 days, or 10 days to get out, 90 days to move or sell the mobile home. We may need to actually have a hearing on this before we get to that point.
Yeah, me and
I'll
Meg
pull the
been
police
speaking of
reports
that.
from those other two cases that I quoted and see if they happened at the park. At any rate, you stay in contact with legal aid. If they are going to represent you, they'll file an appearance. But we will be back here next Monday by Zoom at 2:00.
Your Honor.
I
Yes,
think Meg said she'll be gone on the 8th.
well,
And
if she's
she's
gonna file an appearance, she knows what she needs to do.
Oh, okay.
If you are
I'm
able
not
to,
Go ahead.
if you're able to get copies of those police reports, is there any way that I could get a copy of them as well?
Yes, if they did happen at the park, I will email them to you.
Okay. Appreciate it.
Well, what
All
is,
right, thank you.
what are these,
I'll
what
see
are these
you
police
both
reports
next week.
about?
What?
What are these police reports about?
I don't know yet. One was the DV between you and Randy at the park.
That has
Back in
nothing to
August.
do with nothing.
Yeah, the allegations on that paper
That was
involve
against
him
Dave.
and Dave.
But Dave don't like me. That's the only reason why they're trying to get me out of here.
Well, all right, that's one reason, I guess.
Yeah, well,
Um,
they're gonna have fun, because I ain't going nowhere.
Okay, well,
My trailer's too old to be moved. No trailer out
yes,
here
they
can be
generally
moved.
are. You'd have 10 days to move it
I've
or sell.
been here for
30
11
days.
years.
All right, well.
And I
this will be
also paid
fun.
my rent today.
Say that again?
They're
I-
taking my rent money?
I paid my rent today.
Well, they're not supposed to take your rent once they file a motion to terminate
Well,
your
I've been
tenancy.
paying my rent every month faithfully. I
That
paid
could be an issue, Mr. Crumendike.
$474 last night.
All right, we'll address that.
Yeah, I'll have to take a look at the ledger. It's an online payment system, Your Honor, so I'll have to see.
And if I'm getting evicted, I want my money back.
Why? You're still there. You're paying for rent for time that you're actually there, not future rent. Anyway, we'll address this further
Okay.
next Monday.
What do you
It will be-
mean, why? Because if I have to move, where I need that money, that's why.
Yes, okay. But
Like,
you're
I'm not
living
trying to
there.
be.
You've just paid December's rent. Well, we'll address it next week. It'll give me
Okay.
something to look forward to. Thank you.
It's almost
Thank
$800.
you.
I need that.
Okay. I believe you. Now we got a bunch of people in the waiting room. Plus, we just found out we have somebody in custody. We've got our parties here on our general civil matters. And I don't even know who's here.
Thank you, Your Honor.
We
Good luck.
started off in a rut because we started out 15 minutes late right off the bat. But let's see. I think I'm gonna do McDaniel and that case first. And then Mr. Elliott, you're good to go.
Okay, thank you, sir.
All right. These parties have been advised of their rights. As I indicated, we got behind. Where is he? One of our landlords was here by phone only, Mr. Walters, but we're gonna deal with this one. This is Dawn McDaniel versus Ashley Suter. This is a termination of tenancy case. Ms. McDaniel wants Ms. Suter to move. Ms. Suter, what's your position?
Okay, so Dawn has issues with me as of August because Ryan McDaniel is the landlord of the house and owns the home. I went in and I spoke to him on the last payment I was able to give him, and I talked to him about paying the $200 a week, so $800 a month. Because the house needed work, we agreed on it. Don was nowhere around. Well, Don got a whiff of it, and Don started to harass me. I got like different evictions that she had Daniel Carter bring to me at one point. Then she brought me one back in August, saying I owe $21.50. I don't owe any rent. And then I noticed on the new eviction, she says I owe $78.50. And I'm like, how do you go from $78.50 from August to the time you filed? This has nothing to do with Dawn at all. This wasn't.
Well, at this point, she's not asking you to pay rent. She's asking you to move. So, Miss McDaniel, do you own this house? Your microphone is on mute. Your microphone is on mute.
And I have the proof too. And I've even dropped off money orders to her mailbox. And she had told people she's okay.
Miss Suter, you stop. Miss McDaniel, will you unmute your microphone and join us here?
Judge Middleton?
Yes. She
Judge
claims
Middleton?
that you don't even own the house. What's your response to that?
I can't hear him. Hello? Can you hear me now?
Yes.
Can you hear me?
You're moving to evict.
Okay.
Ms. Suter. There's no lease.
My response
She says you don't own the house. Who owns the house?
I'm the manager for the house because my son owns the house. It's a property that I used to own that I gave my grandma for $1 next door to my
All right,
house.
so your
my old
son
house.
owns the house?
Yeah, he got it for an inheritance. And I'm
Say that
managing it.
again?
He got an inheritance after grandma died.
Okay.
So I'm managing it for her. I actually moved Ashley for 3 days to help her move from her abusive husband, who now lives with her. That was what I was told. And
All right, well, you can't bring this case. You don't own the house. You're not, if you're managing, unquote, managing it, you're acting as a lawyer for somebody else.
Well,
you don't
we
own
tried
the
to get
house. You don't have the authority to evict her. So if somebody else wants to evict her, whoever owns the house, they can pursue it.
And can I
But
say something?
No, I don't need to hear any more. Case is dismissed. Plaintiff does not own the house.
Your Honor, she hasn't paid rent since
No,
June.
I have done, and I turned in money orders, and you denied Ryan to cash them. And I
asked them
Once
to
you
move.
file a termination of tenancy action, you can't accept rent. But you didn't do this right. If he wants to evict her, he can. You don't have standing to do anything.
Okay.
I don't know if she's paid rent or not, but you don't have the authority to kick her out. So the case is dismissed. If he wants to file an eviction, he can. All right, you're both free to go. And Ms. Suter, once they file a motion to terminate tenancy, they can't accept your rent. So this case is dismissed.
Right.
All right, Ms. McDaniel, maybe you can start over again, but this isn't going to get it. Well, that's the kind of afternoon we've been having here today. Everybody had a lot of things they wanted to tell me, but I'd already heard enough. She also got a fee waiver. I didn't make her pay the filing fee. She doesn't even own the place. All right, Ms. Blair, can you hear me?
Yes, sir.
This is Judge Middleton. I had you brought in here because Mr. Walters wants you to move out of his son's house.
Yes.
So let me see if I can sort this out. The file number is 252251LT. It's entitled Richard K. Walters versus Aaron Faith Blair. Miss Blair is currently an inmate in the St. Joseph County Jail and has been for 28 days. I learned that. I didn't put two and two together this morning, Miss Blair. I look at the jail list every morning and I didn't connect it. But Mr. Walters told me you were in jail.
Yes. It's a total different case.
Even though you are in jail, you still have certain rights as a tenant.
Mm-hmm.
You have the right to hire a lawyer. If you
I
cannot
actually
afford
would-
one, you can ask if legal aid would be willing to represent you, or maybe
Mhm.
Andy Rognus would do it. Or you could try to get other legal representation. You have the right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or file the written demand within 5 days of today, pay the $50 jury demand fee. You may be able to reach agreement out of court with the other party, which would result in what's called a conditional order of dismissal, or if both parties are interested in mediation, the court can help set that up. So, Ms. Blair, you're presently in the jail. Do you have an out date?
Not yet. I
What
know
he
there's.
says, he wants you to move out, and apparently you were there living with his son.
I was helping his son, and he put on the eviction that I moved in without permission, which that is a lie. I wasn't even living there when it's his stepson actually. He's actually put his son under eviction too because his son wasn't agreeing with him. I was helping his son. I've lived there since February 26th or 7th, something like that. I didn't even plan on living there. I was just hanging out and helping him and their son Lawrence, which Lawrence passed away in March. And then I was requested by David, which is his son, and I told him without permission, I'm not gonna just move in, but I was helping take care of him and his mother, even at Lawrence's funeral, because Lawrence passed away March, I think it was 1st or 3rd or something. It was just within a couple of days, and I was there to help David because David went septic. I actually was there when we had to call the ambulance. He missed his brother's funeral and everything. It wasn't until I got pulled over in August and had a failure to appear for show cause, which is a $50 payment, but I didn't know about it. They hadn't found it that I got arrested, and the van was impounded. I was on my way back from Celebrate Recovery, and I stopped at Walmart. The only reason why he even wants me to move is because he went and got the car out of impound, which I was told had they waited, they probably would have not even had to pay that fee because it was illegally impounded. But that's the only reason. He's telling everybody around town.
Well,
that
all right, let's back up a little bit. This was the house that belonged to Mr. Walters and his wife. Her son is your friend, and what's his name?
David Wolf.
All right, that's what he said.
But it's not actually
So his mother died, and Mr. Walters owns the house, and he wants you to move out.
His uncle Harry lives
say that
in the
again?
house too. Harry lives in the back of the house. He owns it. Mr. Walters is the power of attorney only. David didn't want me to move out.
I do own it now.
Yeah, now, but you didn't, and you knew I moved in. You asked
At
your
what
brother's
point did you
permission.
become the owner of the house?
I've owned it now for about 5 or 8 years.
Yes, but
Oh.
you asked your brothers or nephews permission for me to move in. So how is that me not giving you permission to move in? Isn't that what it states?
I didn't give you permission to move in.
Yes, you did. your uncle,
No,
All
your
right,
I'm
brother.
not.
stop.
His brother John
Stop.
is the third
Stop.
caregiver.
Miss Blair, stop and listen. Don't interrupt me. We don't have a
Yes.
very good connection here. You're in the jail. You don't have a lease. You live there. You don't own the house. If he wants you to move out, he can ask me to force you to move out. You don't have some innate right to stay there. Even if somebody did say, hey, you can move in February. It's now December. You're in jail. He doesn't like what is going on. He wants you to move out. And he has the right to ask me to enforce that. So you have a right to have a second hearing. So, Mr. Walters,
Yes, sir.
when we do this next time, you need to be here live in person, or you need to do a proper Zoom connection. I don't want to do this by telephone. You keep interrupting me.
I
I can't
understand.
see you. You can't see what's going on. And I
Right.
want you to bring proof that you actually own the house. We're going to continue this to next Monday, December 8th. That may be almost as much fun as we're having here today. December 8th at 2:10. Miss Blair, you're entitled to a bond in your misdemeanor case. You've been in there for 28 days. What's holding you is your felony case with Judge Stutzman.
My attorney was trying to get, because I did explain to her what was going on, she was trying to get it to where I could get it PR bonded. Because she knows that I wouldn't be, she doesn't feel I would be a risk. I mean, I made it to court every time almost ever since I've been, but she hasn't been able to get a bond hearing up.
I'll take a look at your misdemeanor case. In a misdemeanor case, you're entitled to bond after 28 days. And I look for that sort of thing each morning, but I'll take a look at it. At any rate, we're going to visit this again. If you get out of jail, you need to be here next Monday at 2:10. If you don't get out of jail, I'll make sure that you're brought in here. Mr. Walters, I need to see you either live or with a proper connection next week. All
Okay.
right, thank you.
Thank you.
Apologies. Well, that was fun, and we got more to come. We have finished everything that is up to our 145 civil matters, and then we have a number of other landlord-tenant cases pending. We have LVNV funding versus Michael Lord.
Good afternoon,
And
Your
Mr.
Honor.
Jay Baig is here for LVN. Excuse me.
Good afternoon, Your Honor.
LVNV funding, and Mr. Lord is here. Mr. Lord has had a lot of these cases, and he's tried to keep all the plates spinning, sometimes without success. This is an affidavit of non-compliance that the defendant has failed to comply with the agreement, and they're asking the order to enter. Mr. Lord must have sent something because it's an ex parte order, but we set this for a hearing. Mr. Baig, what's the situation here?
Well, the situation, there was a conditional dismissal that was entered on April 10th of 2025. The deal was for him to pay $150 a month beginning April 4th of 2025 and the 4th of the month thereafter until fully paid. It was capped per the conditional dismissal at $900. But if there was a breach, we could, as we did, file an affidavit of non-compliance and ask for the full amount with regard to the $900 limitation, the full amount of $934.29, less any credits for payments made, plus costs and statutory attorney fees. So he has paid the the April payment of 2025, May payment of 2025, June payment of 2025, 150 each, total of $450, and no payments after that. So we're asking for a default judgment with damages of $934.29, cost of $112.13, statutory attorney fee of $75, less payments of $450 for a total of $671.42. Thank you.
Mr. Lord, they're asking to go back to set the original conditional order of dismissal aside. By its terms, if you did not comply, they could file what's called an affidavit of non-compliance. They're going back to the original amount of $934 plus costs minus your $450 paid. So this isn't terrible. You've been struggling with a lot of different debts. We must have 6 or 8 different cases that you've been trying to deal with, and this is one of them. What's your response?
Thank you, Your Honor. It's not a lot of money. I would like to try to make some type of a settlement if I can, and maybe I can just give them a one-time amount. Maybe they can discount it for me, and maybe they won't. My biggest problem is that I made a bunch of agreements and to pay, and I was totally doing that, and I had some judgments too that was forcing me to make payments, and everything was going okay. But then I got a garnishment, and it's a max garnishment, and that kind of took a lot of the extra money I had to pay these guys away, and now just one company is getting it. That's my biggest struggle, is that I'm already getting garnished for 25% of my gross, and I still have all these other.
Well, that undid it. Once somebody jumped ahead of the line and filed a maximum garnishment, and it did it, and well, that's what you were trying to avoid.
Yeah.
So I'm familiar with Mr. Lord because there have been so many of these cases, Mr. Baig. This isn't a ton of money. I'm willing to simply enter the order, and you can talk to them about some lump sum payment. Do you wish to speak to him at all now, Mr. Baig?
I think he could contact counsel of record, the Rusin firm, and try to discuss any further settlement.
All right.
Do you have a phone number for that, sir?
It's on the order that I'm going to send you.
Okay.
At some point, you may have wished to talk to a creditor's rights attorney and discuss bankruptcy as an option here, but you were unwilling to do that. Now someone's jumped ahead of the line.
In the bankruptcy, they want.
I give them a lot of credit for trying to
yes,
not settle. I mean, a lot of credit for that.
Yes.
You know.
I did talk to a bankruptcy attorney a couple of years ago, and they wanted me to sell my house and pay off my debt, and that just didn't sound good for me, my stepchildren.
You can't take your house in bankruptcy. I'd try another lawyer.
I will. That was in Coldwater on the main road there, off the main road.
All right. Well, I've reinstated this, showing that $671. It doesn't show credit for $450 payment.
Look on the bottom there, less payments, $450. The 671 total.
Oh yeah, there it is. Okay. All right. You're going to get a copy of that in the mail, Mr. Lord. Ruslan, Verchetti, and Olivier's number is on it.
Okay.
And maybe they'll work out some flat fee compromise and you can get one less debt. All right, thank you. Good luck to you, sir. Mr.
Thank you.
Big, thank you.
Thank
All
you.
right, for the rest of you, thank you for your patience. Right now, we're about 20 minutes behind. We got off to a late start with our first defendant and then found out the person was in jail and we had people who like to argue. Mr. Lord, I'll remove you from the session. Next, we have Hometown Welcome Program versus the Waxahachie Sun. Mr. Andrew Rognus is here on behalf of Hometown Welcome and Dan Tollefson. I assume Scott is here on behalf of the Waxahachie Sun. This was a substantial judgment, $10,057.38. Hometown Welcome was represented by Mr. Rognus. Waxahachie Sun was not represented. They are located in Waxahachie, Texas. This is not a small claims case. It's a general civil case. And Mr. Scott Brooks is representing the Waxahachie Sun. And I don't believe he's an attorney.
No, I'm not.
But anyway, they filed this action. You filed an answer. They filed a motion for summary disposition and a hearing, and you didn't show up. So on October 13th, I issued a judgment in behalf of the plaintiff for $10,367.38. Mr. Rognus has done a pretty good brief in this matter, setting forth what the standard is to move to set aside a default. One, you have to have a good reason for not appearing, and then you have to have an affidavit of meritorious defense. Mr. Rognus, what's your position here?
Well, Your Honor, I think as we indicated in our brief, you cannot appear without counsel unless you're an individual representing yourself. And in this particular circumstance, no brief, no affidavit, no good cause, and no basis for the motion to set aside the default. I mean, pick any one of those reasons.
Mr. Brooks, what's your position at the Waxahachie Sun?
Well, we responded to what we have received. I'm not an attorney, and I own my company, and so I'm representing myself and the company.
Well, you can do that. Is it a corporation?
Excuse me?
Is it a corporation?
Yeah, it's an LLC.
Well, then you can't represent it. You can't treat it as an independent business for one purpose. Someone sues you and they say, wait a minute, it's a limited liability corporation. I'm only limited to the assets of the corporation, not my personal assets. And then show up to represent an LLC. I'm not sure exactly what the law is in Texas, but in Michigan, an individual can't represent an LLC or a corporation. So that's one problem. You're not an attorney. Secondly, you have I don't know whether there's a meritorious defense, but you did show up for the hearing, and in your letter, you say, it's my fault. Accept my apologies. The reason is entirely my fault. That's not a good reason for setting aside the default that you forgot to come that day. So there, as Mr. Rognus said, there's multiple problems. One, you can't represent the Waxahachie Sun. Two, you haven't stated a good reason for failure to appear. 3, there's no affidavit of meritorious defense. You sent a letter which explains some things, but it's not the same as an affidavit, which is a sworn document. So probably in hindsight, you should have taken this to an attorney as soon as you got it. But I'm declining to set aside the default.
What is the letter that I received saying the court has accepted your motion to set aside default judgment?
I set aside the motion to set it for a hearing, which I just did. That doesn't mean you win.
Well, I'm not necessarily looking to win. I'm looking for a judge to hear what's fair. I don't know what the laws are in Texas as it relates to an attorney. I don't have money to be spending on an attorney for something that I don't think we in any way owe. And all I was wanting was a chance to be able to explain that and let a fair jurist hear it. That's all.
Well, that's a legitimate desire. But this ain't small claims court. You got sued in general civil court. The Michigan rules of civil procedure apply, and there's not special exceptions for lay people. I do grant much consideration to lay people, and I would grant more consideration if this was small claims. But you're in the weeds and you're in over your head. You got sued for $10,000. Your company did. You own the company, but it's a limited liability corporation. So you don't have the right to represent it. It's a separate entity. And so you may wish to have had a jurist hear this. And I've had a number of these cases over the years with small town, local, out of county newspapers, and they're interesting. And I'm sure the Waxahachie Sun is an interesting thing, but don't put it on me.
I'm not putting it on you, Judge.
You didn't know the rules.
I'm not putting it on you. I'm not putting it on you. I'm sorry if I did that. That isn't my intent. My intent is to pursue whatever I need to do.
You made it sound like an insult, like you're not a fair jurist and you're not willing to hear my case. I would have been if you'd follow the rules.
Okay.
Anyway,
right.
The motion to set aside the default is denied.
Okay.
For the reasons stated on the record. Mr. Rognus, do you wish to, Mr. Tollefson wish to speak to Mr. Brooks?
I don't think so, Your Honor.
All right. Mr. Brooks, they'll be in contact about attempting to collect on this.
And they won't collect it. See ya.
Yes, I'm sure that won't be easy.
No, it won't.
Seize your printing press or
Shame on
something.
you guys,
All right,
Dan.
you're good to go.
Shame on you, Dan.
All right, motion is denied. I've signed an order, Andrew.
Okay, but we already have a judgment, so I don't think we need anything additional.
No, you don't need anything else. Collecting on this judgment may be interesting, but the original judgment stands.
Okay, thank you.
Mr. Tollefson, best to you, sir.
Thank you, Judge.
All right, now we are back to our landlord-tenant docket. We got a host of people here. We got sideways, a couple different reasons. Let's see who we've got here. We've got Mr. Berlin on Copper Bay. Is John or Lindsay Fitterling here? Apparently no. Stonehouse is Mr. Tyrone Fleeman, Esquire, and Taya Layton. Miss Layton, are you here? Someone is a Samsung phone. Who's here as the Samsung phone? We'll come back to you. Guess what versus Cassandra Gilbert. Miss Gilbert is here and Mr. Lance Thornton is here. And Lance, I greatly appreciate those judgment forms. Enchanted Glen versus Everlane. That one isn't set till 2:30, so we'll just talk to the three that we got. Mr. Berlin, let's take your case and we'll move ahead.
Thank you, Your Honor.
This is 251939 LT, Copper Bay Company versus John and Lindsay Fitterling. We were here 2 weeks ago. The defendants indicated they were going to pay the check the next day. And that was how we left it. What's the status here, Mr. Berlin?
The defendants have made a substantial amount of payments, but they've not caught the rent all the way up. And so at this point, we're still asking for a default judgment. The rent to retain possession.
Stop for a minute. Someone's logged in as iPhone. Let's see who this is. I still don't know who Samsung is, but let's see who iPhone is. Somebody is logged in as iPhone 3. Who am I speaking with? You're on mute.
Judge, I believe it's Haley Klein.
All right. Thank you. All right, we'll deal with her. All right, Mr. Berlin, here's iPhone 3 again. What's the current arrearage?
The rent to retain possession is $1,675. There is other money due, which consists of utilities and NSF fees of $1,065.27, court costs of $282.20. So the total possession judgment amount is $3,022.47. We're also seeking.
That is through December?
That's correct. December is due as of today.
All right, you had sent me a judgment last week, but the numbers don't match. They've paid a substantial amount. I'd ask you to email me a current judgment.
Certainly. The
3B civil at stjosephcountymi.gov. It's on the notice there.
Okay. All right. We will. Yes, I will email that in.
These Copper Bay properties are among the nicer, but certainly higher end properties. So when the people get behind in these, they get really behind. We'll see, although they must have made a $5,000 or so payment. But $3,022.47. The date for the writ is 10 days from today, which would be December 11th.
Thank you. And Your Honor, we're also requesting a money judgment here.
All right.
Our damages for that are $906.40. Our costs are $282.20. So the total there is $1,188.60.
All right. If you send me the possession judgment and the money judgment, I will sign it.
Thank you very much. I will get that sent in.
All right, thank you. Oh, wait a minute. Oh, I did have it. Just in the exact numbers he quoted. I just released it. Well, we'll have it twice. I couldn't find it because it was right in front of my face. All right, let's keep plowing away here. I'm not sure. We got backed up and then here we are. Stonehouse versus Taya Layton. That would be Mr. Tyrone Fleeman. Miss Layton was here last time. The matter was continued into today. She indicated she had asked for emergency assistance. We actually adjourned this for 2 weeks. Is anyone here on behalf of Taya Layton? All right, Mr. Fleeman, good afternoon.
Good afternoon, Your Honor. I have not heard from Miss Layton, and I would therefore be requesting a default possession judgment indicating rent to retain $4,054 through December, utilities of $131.38 for a total, court cost of $194.20 for a total possession of $4,379.58. I do not believe a money judgment was requested, and I can submit a judgment as soon as we're done with my couple of cases here.
Yes, that matter was set for 2:05. She's not here. Plaintiff will submit a default judgment. I went to see Paul McCartney with 30,000 of my closest friends who came away with this terrible cold. I don't know whether to blame them or my grandchildren, but I've been struggling since then, so excuse me.
I'd blame Paul if it were me. Just saying.
All right, Miss Gilbert is here with us. Miss Gilbert, can you hear me? Let me put it this way. She was here with us.
Yeah, she was. Oh, she's still there, just muted out.
Oh, Cassandra, would you rejoin us?
Can you hear me now?
Yes.
Okay.
All right, we also adjourned this for 2 weeks from November 17th to now. I was gone last Monday. We determined at that time rent and costs through November were $4,048.40. You were also seeking emergency financial assistance. Mr. Fleeman, what's the status here?
Your Honor, looks like I'm still looking at a balance $4,054 in rent. Oh wait, I'm sorry. Wrong file. Let me go back to the right file here.
Boy, that's very similar to the last one.
That's what caught my attention. I'm like, wait a minute, that can't be right. No, the balance for this one is $4,475, including December. There was a $350 pet fee on the ledger, $198.40 for court costs, for a total $5,023.40. At the last hearing, Ms. Gilbert indicated that Neighborhood Inc. was going to, quote, catch her up, but I was emailing with Ms. Collins, and they've not received anything from Neighborhood Inc., including request for a ledger, which is something that normally happens, at least with DHS. I don't know if it does with Neighborhood, but I presume it does. So we don't know anything beyond that, just the balance is still outstanding.
Ms. Gilbert, what's your position?
I did this morning through Livable. I had to pay. Neighborhood wouldn't help me until I paid at least $1,500, and then they would help me. I did pay the $1,500 just not too long ago. I had to do it on the portal because I have COVID currently and not supposed to go out. But I did, and I did send in a $400 check also and put it in the Dropbox.
Which agency did you say was going to help you?
Neighborhood, but they.
I thought you said Neighborhood Inc. would not help you.
No, Neighborhood's the one that said they would help, but when I talked to them, they told me I had to come up with at least $1,500. So I took a $400 check and I did the rest on the portal.
All right, well, we'll see. You're gonna get a judgment. It's gonna
Um,
have these numbers in it. Now, if that money is credited to their account, it'll be removed.
And
But
then I
through
have the
December,
Yeah, and I have December's payment. I'm gonna see if my aunt will take it up there here in a few. I do have December's payment, so.
all right. The date for the writ is 10 days from today, which would be December 11th.
okay, and Your Honor, I will go ahead and submit that judgment. And I have an email for Miss Gilbert, so I'll email her a copy of it at the same time I send it to the court in case.
All right, so you take that to Neighborhood Inc. and they can see the numbers. And if you've paid December's rent plus $1,900, perhaps they'll give you some assistance. That would be very helpful. Otherwise, remember I told you, you have to pay the entire amount. Payment of a partial payment will not prevent the writ of eviction. So stay in contact with your manager and stay in contact with Neighborhood Inc. We'll get you a copy of that judgment here shortly.
Okay.
And
All
Miss
right,
Gilbert,
do you have
I
any
think you should.
questions?
No.
And Miss Gilbert, I think you should reach out to Miss Collins to talk about that portal payment. I'm not sure if the portal would take a payment right now. That's what I'm a little curious about that. So definitely check with her, make sure that those payments have been received and stay in
Okay, I
contact
will
with her.
The manager, Chrissy Collins, is also present. Ms. Collins, did you know whether you've received any of those payments?
I have not received a $1,500 payment.
All right, well, let's see where this goes. Ms. Gilbert, unless this is paid in full, you're subject to being evicted. So keep that in mind. They can agree to work with you, but they don't have to.
Okay.
All right, very good. Thank you.
Thank you, Judge. I'll get that filed right away. Thank you, Chrissy. Next
up is Enchanted Glen versus Everling, and that's fraught with difficulty. So I'm gonna set it aside for a minute. Next up then would be, well, no, we're not. We're at 2:15. We're at Mr. Thornton's cases. We've got Leandrew tomorrow and then Chrissy Klein, who's iPhone 3, I believe. Good afternoon, Mr. Thornton. Mr. Tomorrow, can you hear me?
I can. Can you hear me?
Yes. Mr. Thornton has given me a judgment information sheet indicating that through December, they believe you owe $2,390 plus water fees for November and December of $130, plus court costs $68.75 and $41.33 for a total of $184.33 for total rent and cost through December in the amount of $2,704. Is that correct, Mr. Thornton?
It is, Your Honor.
Those make things go so much faster. Mr. Tomorrow, what's your position?
I was unable to get help, and the numbers do seem correct to me.
All right, maybe you can get some help. These were all adjourned. Well, this was only adjourned 10 days. But I'm going to sign the judgment. Rent through December is $2,390. Utilities are $130. That's water. Court costs are $184.33 for a total of $2,704.33. And that's due within 10 days from today. I didn't pull that out of a hat. That's what the statute says. That'd be December 11th. After that day, you're subject to being evicted. You also have until December 11th to appeal this. No money judgment is entered at this time. And as I told the last lady, A partial payment will not prevent a writ of eviction. The only thing that prevents it is paying the entire amount of the rent. So my advice is always stay in contact with your management and your funding agency. If you're going to get some emergency help, share this judgment with them forthwith. Otherwise, you should plan to move on or before December 11th.
Yes, sir.
Do you have any questions?
No, sir.
All right. I'll send you a copy of that forthwith.
Thank you.
All right. Thank you. Our next matter is Sturgis Place Apartments LLC, Phase 1 versus Haley Klein, Anna Schmidt, and all other occupants. We were here last November 21st, 10 days ago. Lance Thornton was here, manager Julie Daly was here, and Haley Klein. We determined at that point the rent was $3,828.02. Defendant indicated she was going to catch up on the rent. I don't think that happened. Mr. Thornton filed a judgment information sheet showing that rent is $4,892.54. Utilities and rent insurance are $178.82, and court costs are $241.60. So the total amount due through December is $5,316.96. Is that accurate, Mr. Thornton?
Yeah, it's $5,312.96.
I'm not sure what I said, but what's written is $5,312.96.
That is correct, Your Honor.
Ms. Klein, what's your position?
I am picking up more hours. I'm looking into a second job as well. I did have someone try and come look at the car. Unfortunately, they crashed, so they weren't able to make it. But I am working on it. I do have my first paycheck this Friday, I believe, or Thursday. I'm not quite sure what day. And my check will be going to my rent.
All right, well, maybe you can sell the car right in the middle of a blizzard. It's not a good time.
I know.
It's a hearing as to you, a default as to Anna. She's not living there, but she is a co-signer. Through December, rent is $4,892.54.
Before you get too deep into there, Your Honor, the last time you'd mentioned you were going to deduct $50 for the 2 late payments. So you'd have to take $100 total.
All right.
My total.
$4,782. Thank you, Lance. $4,792.54. Utilities are $178.82. That also includes insurance. And $241.60 in court costs. The late fees are up there with the rent, and I've reduced it by $50 for October and November. We haven't charged a late fee for December yet. So the total amount due is $5,212.96. There could be another late fee for December. And the problem here, Ms. Klein, is you have to pay the entire amount. Partial payment will not prevent the writ of eviction. That's due within 10 days, which is November 11th. The landlord can agree to work with you to try to get caught up on the rent. They don't have to. By the letter of the law, you have to pay that entire amount by that date, or you're subject to being evicted. And then when they go to collect money damages, they could also sue Anna Schmidt.
Okay, Your Honor.
So my advice is always the same. Stay in contact with your manager. If you do work out some sort of repayment plan, then they can do that. But unless you pay this entire amount by the absolute letter of the law, you're subject to being evicted on or after December 11th. All right, you're good to go.
Thank you, Your Honor.
Thank you. Mr. Thornton, thank you.
You're welcome.
All right, Jordan, we're gonna take your matter up. We got a couple clinkers here, including Enchanted Glen. Meg Bauer has joined us on Enchanted Glen. And we'll address that. Yes,
Judge, could Meg and I have a breakout room?
yes, that'd be great.
I'm sorry, Meg, were you gonna say something? I didn't.
I was just going to indicate to Judge that I'm doing double duty here today, and so
Yeah, I understand you had a bench trial going on, so I'll let you and Mr. Popovich talk. Do you want the manager too?
No, not right now. I'll just leave Kim.
right.
Meg and I can probably be efficient.
All right, I'll just take care of other business.
thank you, Judge.
All right, Jordan Harden is here from the mega law firm of Yancey and Harden, and she's representing V Squared Ventures. Carissa Finnerman-Rarick is here on behalf of them. We were here on November 21st, and we learned that there was a substantial arrearage. Ms. Harden has prepared two judgments. I think the most recent one is the accurate one.
Correct. While we were waiting for the hearing, my client provided new information about an electric bill that had come in today's mail, so I updated the judgment and breakdown to reflect that additional cost.
So rent through December
Correct.
is $2,050. Court costs are $160.29. Water, electric, and late fees are $60, $116.40. And that would total $216.42 for a total amount due through December of 2024-26. Is that correct?
Correct. It's $2,426.71 due and owing to the plaintiff.
All right. I don't know what I said, but that's what's printed there.
Threw an extra
Ms.
number in
Poling,
there.
what's your position?
Can you say that amount again?
$2,426.71.
Okay. Sorry, I was just trying to write it down.
Well, I'm gonna send it to you.
That's fine.
You have 10 days to pay it or you're subject to being evicted.
Okay.
10 days from today is December 31st. Excuse me, December 11th. Get ahead of myself. That's 30 days from now, December 11th. It's also the day for the appeal. Partial payment will not prevent the writ of eviction. You have to pay the entire thing.
Okay. I get paid this
withdraw.
Friday, so I
All right.
should be able to pay the majority of it by this Friday.
Very good.
I would have paid more by now, but I found out over the weekend that the holiday pay at my work I couldn't access through my daily pay, which is like I can access money before my paycheck. They don't allow you to take if it's holiday pay. It just automatically goes to my paycheck. So I was planning on paying more this weekend, but I wasn't able to get money.
All right. Well, that sounds like you have a plan. Stay in contact with your landlord. Excuse me. They can agree to work with you to get caught up on the rent. They don't have to, but it sounds like you're going to get a bonus for the holiday, and that may help.
Oh yeah.
Get caught up by December 11th. All right, $2,426.71 is the total amount due. All right, you're good to go. Thank you, Ms. Harden.
Thank you, Your Honor.
All right, let's take another look at Green Valley versus Gushwa. Mr. Gushwa, I can see him, but I can't hear him. Mr. Gushwa, nod your head if you can hear me. All right. Elaine, Lance re-emailed that judgment to me and to you. Would you bring it in to me, please? I'll go to my email. He sent me the judgment, but not the judgment information.
Well, there is no judgment information. This is a termination.
Oh, it's a termination of tenancy. That's why I couldn't find it. He planned to move. He was, all right. He was going to vacate. He wanted to vacate by December 15th. So we continue the matter until today. If I give you the standard, it would be by December 11th. Mr. Thorne, do you have discretion to go to December 15th?
No, Your Honor, my client's here with me, and this has been a long time coming, and Mr. Gushwa's had a lot of time, so we'd ask for the standard 10 days.
Mr. Gushwa, you have until December 11th, which is 10 days from today, to vacate, or you're subject to being evicted. December 11th is a Thursday. More likely day would be Friday, December 12th. So keep that in mind. I'm going to send you a copy of this order as soon as I get it from my clerk. I probably had it and did something with it. Anyway, you've got 10 days to vacate. This lease has been up for some time. They filed a notice of termination of tenancy. In fact, I don't think there even was a lease. The termination of tenancy notice was filed a long time ago. They want you to move, and it's just time. All right, Mr. Gushwa, if you have any questions, I can't hear you, but you heard me. You got till December 11th to vacate. All right, thank you, Mr. Thornton.
Thank you, Your Honor.
That judgment is coming. So I've got Enchanted Glen versus Everling, and the parties are in discussion. I'm going to remove Mr. Kushwa. Let's find out I've also got a vigorous small claims docket with 7 cases on it, except for 3 o'clock. Let's see who we've got. The lady with the Samsung and the ceiling fan is going to give me vertigo. Who am I speaking with? Samsung? What's your name? Good afternoon. You've got a Samsung phone and a ceiling fan. What's your name? That's kind of day this has been.
Can you hear?
Yes. Who am I speaking with?
Cassie Hershey.
Okay. Then I've got Walter's iPhone.
Difficulties.
All right, let me sign this. These judgments got separated from those files. You can have those.
Okay.
All right, so we got people here for our other cases. I have 7. Because Kim thought it would be good to do 7. I've got Brenda Cranfill, Jose King, Cassie Hershey, she is present. Kimberly Carter. Jeff Hawker and Walter Banks are both present. Madison Shelton is here, but Kaylee Zablocki is not. And I've got Jennifer Patterson. Who are you here on behalf of?
I am here with Enchanted Glen.
Okay, thank you. As you can see, we're in hurry up and wait. It's not yet 3 o'clock, so we've not yet used up all our landlord-tenant time, but we've got multiple one landlord-tenant case to do, and then we have 7 small claims matters to address. So everybody just stay with me here. I'll wait while the attorneys are discussing things on our last remaining landlord-tenant case. Well, this is time we could be using for other things, but we'll just stay where we're at.
Yes, hello.
Yes, what's your name, sir?
Job King.
All right, you're in the right place. We got a lot going on, so it'll be a minute before we get to your matter.
Okay.
All right, we have a bunch of landlord-tenant cases that have been completed. We have one more to do, and we have a lot of people here who are waiting for their turn for small claims cases. Okay. So the case we're going to address is Enchanted Glen versus Everling. Started out as English, Evan English and Amy Everling. File number is 1769. We've been kicking this can down the road since September 12th. This is a non-payment of rent case. We've been trying to pin the number down. Meg Bauer is here on behalf of the defendant. Greg Popovitz is here on behalf of the plaintiff. Their manager is here. She's on the phone. And we've also got Jennifer Patterson, who's here on their behalf. I'll defer to you, Mr. Popovitz. What's the status?
Meg and I are adamantly trying to work to resolve this because you've indicated it's been kicked down the road. We had a conversation. If we could both have breakout rooms with our client, we're talking substantively and maybe with some ability to give these parties some closure.
All right, let me see what I can do here. I'm going to try to get in over my head.
So I would take Enchanted and Jennifer as well. Sorry.
I try to open 2 rooms. Every time I do that, I get sideways. All right, I'm going to assign Meg Bauer and Abby Everling to room 1. And I'm going to assign Greg Popovitz, Enchanted Glen, and Jennifer Patterson to room 2. I'm so proud of myself. All right, let's see if I make this work. Everybody join the room. I'll be here.
Thank you, Your Honor.
Thank you, Judge.
All right, it is at 3 o'clock, which means it's time to start our small claims cases. We have several. The rules are different for small claims cases. Let's see if we've got some of our parties here. James Seifert or Rich Truckee. Either one of those parties are here. Jeff Hawker versus Walter Banks Jr. Both parties are here. Madison Shelton versus Kelly Zablocki. Madison Shelton is here. Kelly Zablocki is not. This was entered as a default, and then it appeared that Ms. Zablocki had actually never gotten served.
Mr. Truckee called.
Yes.
He said he will not be here, neither in person nor by Zoom.
All right. Do we have service on Kelly Zablocki?
She's the one that came in and filed and she should be showing up.
No, she's not. Then, so apparently no one's coming on that one. That's $4,500. We'll see whether anybody shows up. We have Rogelio Segundo from Aaron's, and let's talk about his cases. Aaron Sales and Lease versus Brenda Cranfield, 252215. We have no service in that case. We'll come back to it. Aaron Sales and Lease versus Joby King. Mr. King is present. Aaron's Sales and Lease versus Kimberly Carter. She's not here. She did file an answer. See what her deal is. Must be missing a couple cases, Rogelio. Carter, we have an answer, but no defendant. We don't have service on Brenda Cranfield. We do have two parties here, Joby King and Cassie Hershey. Someone named Jim just showed up late to the party. Is that James Seifert?
Yes, it is.
All right. Could you turn your camera on?
Any luck or?
No. When you're the plaintiff in a case, it's generally a good idea to show up on time.
Yeah, a little bit of technical issue here.
Yeah, the time to practice isn't 1 minute before the show starts.
Yeah.
All right. We'll come back to your case while you're looking on that. We're going to take up, well, for everybody that's here, let me tell you what the deal is. You're in small claims court. It's a different division of the 3B District Court. My name is Judge Middleton. I do the vast majority of the civil cases here in St. Joe County. Certain category of those are small claims cases. They're for claims of $7,000 or less. Neither party is allowed to have an attorney. There's no formal record being made in small claims because there's no appeal. You don't get to appeal a small claims court. Any judgment, any decision here is final. Either party has the right to ask the court to remove the matter from the general division, from small claims to the general division of the court. But if you do that, tell me before we begin. Excuse me. Wonderful. Anyway, Mr. Hawker, do you understand that once we begin, any decision here is final? Could you unmute your microphone?
Yes, sir.
Mr. Banks, you understand?
Yes, I got a request of the court, Your Honor.
Yes, sir.
I'd like to request that the court dismiss the case against me based on the court lacking personal jurisdiction, as I do not reside in St. Joe County, and the court lacking subject matter jurisdiction, as the claim did not arise or any action or occurrence that happened in St. Joe County.
Well, Mr. Hawker lives in St. Joe County, and I have jurisdiction over you because you're here. He's claiming the statutory maximum, $7,000. He claimed he purchased a pair of jet skis from you, advertised as working units. The engines are bad. He spent $8,200 on these jet skis. Now, normally buying something used without a warranty has got issues with it. But anyway, your motion to deny for lack of jurisdiction is denied. A, you're here. B, he lives here and he bought these here.
No, Your Honor, he bought them in Calhoun County.
All right, but he lives here. He lives in Sturgis at Lake Champlain. Mr. Hawker, why do you believe he owes you $7,000?
When I purchased the jet skis, he said that they were good units. They run, although he purchased them a year and a half prior to my purchasing them from him. He did not use them, but he still said that he would still stand behind them. So I brought them home. I put oil in them, and the one unit would not even start. So I took the units to the dealership in Kalamazoo, Ziegler Power Motorsports. They tested the unit that would not start and said that the compression was bad on all 4 cylinders. And they could not repair it due to not being able to get parts. It was such an old unit. The second unit I brought home. I could at least get it started, but I put it in the water for a test run. It blew out smoke, and then the engine seized up, and neither units are functioning. And the maximum damage allowable would be the $7,000. So that's what I am asking for.
All right. All right, let's see what we got here. How did you find these? Craigslist?
Yes, sir.
You understand how foolish this is? Gee whiz. 2028 Yamahas. They're almost 20 years old. There's no warranty from the company. Did he provide any warranty?
He said that they were good units and he would stand behind them. He
I'm
would
not sure that
sell
rises
them.
to the level of warranty. Mr. Banks, what's your position?
Yeah, I purchased them, like I said, a year and a half ago. I never used jet skis. I invested $1,500 to $1,800 that I in equipment, new vests, new batteries, ropes, fire extinguishers. Due to a injury to my shoulders, I wasn't able to use them. I purchased them as is. Like I said, never did anything, never had them in the water. And due to the fact that he had opportunity to grab them and test them before purchase, like other people had contacted me and asked they would have to do start them up and do a sea trial or whatever they needed to do to purchase them. He had that opportunity to do as well, but he chose not to, and he bought them as is. Like I said, I did give him all that stuff for free. I am well over 11,000 in new stuff that I added that I just gave to him with the jet skis. New tires, new fenders. I gave him the old tires as well. So
So
4
this
tires.
included the trailer, a dual trailer and all of that?
Yes. plus the extras that I bought and purchased to ride them, but I never got to. So I'm 12 grand. I gave him over about 12 grand worth of stuff in the deal.
You're both very foolish. You're selling something and saying it's operational, and you never even put it in the water yourself. You're either fraudulent or willfully ignorant of whether these would run or not. They sat for some period of time without running through the winter. Don't know whether they're winterized properly. Don't know whether they were sealed. Mr. Hawker, you're even more foolish. You see a Craigslist ad, you give a guy $8,200 for something and never bother to see whether it'll run or not. You also are now the owner of a trailer. He's not a dealer. He didn't provide a warranty. And so I'm not sure who's more foolish than the other. He sold them for $8,200. The trailer, how much is the trailer worth?
$4 grand alone.
That's hard to discern what a used trailer is. It looks like a nice trailer. So the way this works, he gets to keep the stuff and you owe him $7,000. So he sued you in small claims court. He's not saying, I want you to take the stuff back. I just want $7,000 for a functionally functional dual trailer and 2 wave runners that I never bothered to test. That seems unfair. He keeps the stuff, including the trailer, and you pay him $7,000. That's a pretty good deal for him, not such a good deal for you. The other side of the coin is he gets nothing. You sold him this stuff without a warranty. I'll stand behind him. I wouldn't exactly say it amounts to a warranty. You're not a dealer, and he never tested them. And he gets to keep the trailer, which I'm not sure how much it's worth. I owned a wave runner trailer at one time, a long time ago, and it was steel, not aluminum. So, Mr. Hawker, what's your last word here?
I will accept the court's decision.
All right, I don't like it really when you step back and look at it. I've said he's selling you this stuff that he doesn't even know whether it works or not. Expensive motorized equipment. He never bothered to start it, although neither did you. He made improvements to it, put new tires, fenders, other ancillary equipment like jackets and that sort of stuff, selling you saying, hey, I guess it works. In small claims court, the same standard of proof applies as to regular court. The burden of proof is on the plaintiff, and they have to prove the case beyond a preponderance. There was culpability on each side, on the seller's side for not knowing whether the thing even worked, on the buyer's side for not first confirming that 2 expensive pieces of water equipment that are almost 20 years old worked. I find a tie, in which case the tie goes to the defendant. Plaintiff has to prove the case beyond 50%. Mr. Hawker does have these devices, which apparently have some value. And he also has the trailer, which may have some value to recoup against his $7,000. But allow him to keep both units and the trailer and $7,000 just is too unfair. The defendant was a private seller. He was not a dealer and there was no express warranty. So I find for the defendant, the damages are 0. Mr. Hawker, perhaps you can sell some of this stuff and recoup some of your investment. But I find for the defendant. All right, thank you both.
Thank you, Your Honor.
I'll move Mr. Banks. Now, Kelly Zablocki showed up late to her own party. This is complicated. And I'm gonna do that one last. I've got James Seifert, who's got 1 foot in it. Mr. Seifert, could you unmute your microphone?
Can you hear me?
Yes. This matter is James Seifert versus Rich Truckee. File number is 251975SC. Mr. Seifert hired Mr. Truckee to do some seawall repair at his property in Portage, paid him $4,500. Mr. Truckee never performed the work. Summer's over, fall's over, it's hard winter, and he hasn't returned $4,500. Mr. Truckee called a few minutes ago and said he wouldn't be able to be here. If he could call us, I guess he could call into this. Mr. Seifert, wherever you are, will you raise your right hand?
It is raised.
Or you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
Did I recite the facts correctly here?
Yes.
He has $4,500 of your money and you have no seawall.
Yes. Needs repair.
Yes. So does mine. I guess I won't hire this guy. All right. Well, he's not here and he's knowingly not here. And I find by default that he owes you $4,500 plus $88.25 in court costs and $93.22 in service.
That's correct. There's actually another 46.76.
Well, he owes $4,679.47.
Yeah.
Well, getting the judgment is the easy part. Getting the money is the harder part. He has 30 days to pay this, and if he does not pay, excuse me, you can pursue what's called a discovery subpoena. And try to compel him to come in here to address his ability to pay on this debt. This is also something called violation of the Builders Trust Fund Act, where it takes the money from your job and applies it to somebody else's job. You also need a license to do this. I don't know whether he's a licensed cement contractor or seawall repair, but you need a residential building and alteration contractor's license to do it. Anyway, I owe you $4,679.47. If you don't get your money, I suggest you come in here to the court in December. Thank you, but I can't do lemon. And ask for a discovery subpoena that would compel him to come in here. All right, are you still at the East Shore Drive in Portage?
Yes.
All right, we barely made it through here, but we did. I'm giving you your judgment that you've requested. If he does pay, great. If he doesn't, you need to pursue a discovery subpoena.
Discovery subpoena. Okay. Thank you.
All right, let's take the two that we got. In Mr. King's situation, I get these Aaron's cases mixed up. I reviewed the cases last week and again earlier today, but sometimes I lose my facts. Mr. Segundo, you're asking for $1,079.54. The stuff that he rented is unreturnable due to cat scratches and cat smell, also refusing to pay. The items rented were.
It was a sofa.
Sofa. Mr. King, what's your response?
Well, I had lost my job, and I've been in contact with them and telling them that like I lost my job, and we've been door dashing and stuff like that.
Okay. You still have the couch?
Yeah.
Where were you working?
I was working at EIMO.
Okay.
I've been trying to get a job, but I thought I had a job here in Constantine. They called me and they said that they're just gonna go with further candidates, and I was like, all right. But they said if they have another job position that they'll give me another call back. So I'm just waiting on a call back.
Well, at least they called you. A lot of places are ghosting people.
Yeah.
All right. Well, it appears you rented this stuff. I don't want to rent anything that smells like cats and has scratches on it. So they can't really take it back.
Yeah.
So I find that you owe $1,079.54 plus costs of $66.25 and other of $42.59 for a total of $1,188.38. Can you make any sort of monthly payment?
I mean, yeah, I can by door dashing. Try to come up with some money, like
Can you
$50.
pay $100 a month?
Yeah.
All right. Installments of $100 per month. We won't start this till January 15th, 2026. That'll take about 12 months to pay it off.
Okay.
Who's your biggest DoorDash restaurant?
I'd have to say probably at a restaurant, probably like McDonald's, but we mainly be door dashing for like Myers and stuff like that.
Okay.
Yeah, that'd be the bigger ones, Myers.
That makes some sense, but the DoorDash from McDonald's.
Yeah.
All right, Mr. King, I found that you owe the money. We're going to repay it at $100 per month starting January 15th of 2026. $1,188.33, and the couch is now your possession.
Okay.
Cat scratch fever and all. All right, Mr. King, thank you for your patience.
All right, so yeah, blessed day.
All right, you're good to go. All right, Miss Hershey, can you hear me?
Yes.
All right, this one is a claim for $3,719.52. Let's take a closer look at your case. You're both under oath. You both explained the circumstances of small claims court. Let's see what we're talking about here before I get my cases all confused. This is a claim for $3,719.52. Customer is not working or making any plans to pay. We've retyped the account to lower the payments. Items are not returnable. TVs are broken, furniture was destroyed, is not able to be resold, and she has bugs. So it sounds bad all the way around. Mr. Segundo, what's the status here?
So we try to maintain communication with her. She'd answer the phone and everything. But every time we try to talk about a payment, she would say that she's not working, and then really had no plans on when she could make a payment. If she had given us a date, we would promise the account. We wouldn't even be calling her, but yeah, we were trying to at least see if like she's working or trying to work or something. She said she's looking for work, but I mean, we haven't
All
received
right,
the
well, let's
payment at
talk
all.
about everything that's in there. Upholstered, you got a PS5, a 55-inch television set, a soft sofa chase, a rocker recliner, a 72-inch TV stand, 55-inch smart TV, an 8-inch queen foam mattress, 8 foot, a 9-foot foundation mattress encasement, and a twin queen frame. So it's bedding, upholstered furniture, and electronics. And she presently has all of it,
Yes.
and none of it is returnable.
No. Yeah. I mean, even the stuff that she was trying to return was either broken or had bugs.
Ms. Hershey, what's your response?
I was telling them that I wasn't working because I haven't been able to work since I got pregnant, and I did lose my job at American Axle, and then because I got pregnant, and then I got evicted from my apartment, so I lost the furniture to the storage unit that we had to put it in because I wasn't able to pay the storage unit either.
All right, well, this is easy. No longer can you even return this stuff. It's a risk of rent-to-own, renting and borrowing to rent. How long were you at American Axle?
I was at American Axle for 3 months.
All right, well, you owe this money. You rented their stuff and then you took it and then you either broke it or lost it. You owe $3,902.67. I don't think you're presently in any position to make any payments on this. What, are you at Lafayette Street, B6?
Yeah. Yeah.
All right, well, this is a very unfortunate situation. You got in over your head, you rented all this stuff, they rented you a whole bunch of stuff. People can't live without a PS5, 2 TVs. Judgment for plaintiff is $3,902.67.
That's how much I owe?
Yes. Now, for what it's worth, it won't continue to have monthly debt from rent-to-own, but there is interest on this. You don't presently have the ability to pay it. I suspect what they will do is a discovery subpoena. When is your child due?
March 22nd.
Well, good luck to you. That's a good day to get born, I think, but you're not in a position to pay anything right now. So I'm not going to order it, but you do owe the money. You took their stuff, you didn't return it, and it got lost. This judgment is good for 10 years. So if your circumstances change, they can attempt to collect on it. But you're free to go. Rogelio, you know where she is if you wish to do a subpoena.
Yep.
Okay.
All right, Ms. Hershey, best of luck to you.
Thank you.
Next, we have Aaron's Sales and Services is Brenda Cranfell. We have no service in that case. And I'm going to continue that for 60 days. For 60 days to try to obtain service. Any idea where she is?
She's still there. She just won't answer the door. She actually threw everything outside, and we were gonna go out there to pick it up, but we noticed bugs, so we left it alone. Like it was really bad.
All right, well, we'll try again. Next, we have Aaron Sales and Lease versus Kimberly Carter. We do have service, we do have an answer, but she's not here. It's a claim for $2,291.13. Have you had any contact with this defendant?
For a little bit, we were trying to figure out a payment plan that would work for her. She said she split up from her boyfriend and he was helping her out for a little bit, but after that, she just didn't make a payment again after we retyped it and lowered it.
She did file an answer, but she didn't appear. So default will enter in the amount of $2,291.13 plus costs of $86.25. Total of $2,377.38. Again, getting the judgment's the easy part. Getting the money is all hard. All right, Mr. Segundo, that finishes us for today.
All right.
Now, I still have all those people from Enchanted Glen in various breakout rooms. They must be really talking. But I have Miss Shelton and Miss Zablocki. So Miss Zablocki, would you join us, please? This is a claim for $3,055 plus court costs. Madison Shelton versus Kelly Zablocki. Will you both please raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes. Yes.
All right, let me back up. We were here some time ago. This had to do with money that was allegedly borrowed by the defendant from the plaintiff. The amount of $3,055. Ms. Shelton was here on September 2nd, and Ms. Zablocki was not. So I entered a default judgment on behalf of the plaintiff. Ms. Zablocki then wrote me a letter, October 21st, and I wrote her back saying there is no appeal from small claims judgment, and you didn't show up. And you didn't file the demand to set it aside within a timely manner. Then the clerk gave me something. What's a date stamp on this? November 10th. We learned that Kelly Zablocki never got served from the Postal Service on November 10th. We got the certified mail returned to sender. Now, somebody signed for it on August 11th. Sue Chandler signed for this letter. So I accepted that as a certified proof of service. I don't know who Sue Chandler is. And then eventually the letter came back indicating that Kelly Zablocki had never actually gotten notice of the hearing, which is why she didn't show up. So we'll come back to that in a minute, ladies. So the letter that I wrote to her telling her that she couldn't move to set the default aside is in error, because if she was never served at all, then she can't be excused for not appearing for the hearing. Although we didn't know that until the Postal Service sent us something on November 10th, well, after all this had taken place. So ladies, bear with me for a minute. Ms. Bauer, is everybody done?
Judge, I believe we have resolution. I'm hopeful.
Okay.
I indicated to Attorney Popovits that we would be leaving our breakout session and see him back in front of.
All right, well, I'll continue to proceed on this other case. So, Ms. Shelton, you were here back in September, and we made a finding in this case. I put you under oath, and you believe, now this was convoluted. It's a bunch of emails and screenshots and text, and I frankly can't tell what is what. You did give me, however, a breakdown accounting of why you believe that she owed you this much money. And we sort of went from that. Miss Blocky, do you have that in front of you?
I'm sorry, what'd you say?
She gave me a breakdown of that adds up to $3,055 of this money that she says that you owe her.
Okay.
So it goes back to December of 24, $900 December, 122 paid $200, $700 due. January 31st, $1,200 rent. Now it's $1,900 due. Paid $600, $1,300 due. Paid gas, food, no food stamps. $82.50. Now she says you owe $1,382 through February. Then February 25th, paid electric, food stamps, $295 divided in half is $147.50. She claims you now $1,529. March rent paid, gas paid, cut in half, $81 due. Through March, she now claims you $1,610. Electric paid, $266, cut in half is $133. Now the total is $1,793. Then rent of $1,200 for March. Total now due is $2,943. Water bill cut in half, $112. That's how she came up with $3,055. Ms. Shelton, is that correct?
Yeah.
All right, let's hold that thought for a minute. Everybody's back on my other case. All right, so she tracks it month to month and with payments and credits and other amount due. We have everyone back in Enchanted Glen versus Everling. Welcome back, everyone. We've been working on other business. I've been trying not to fall out of my chair from this cold I have. I'll defer to you, Mr. Popovich. What's our status here?
Your Honor, we're able to place, oh, there we go. Your Honor, thank you very much. Gary Popovich appearing on behalf of Enchanted Glen. We were able to, through 2 private breakout rooms, reach an agreement. I can place a portion of it on the record, and Ms. Bauer can certainly chime in and correct me if I make a mistake. But the parties have agreed to a negotiated amount of $3,998.80 to be paid by January 31st.
All right, that's through December?
Through January.
Through January.
There is a new lease that's prepared to be signed. That's will happen with the complex, and the current rental rate is $5.99. And there was a negotiated amount through November, but the parties have agreed that $5.99 would be paid for December and for January, and that amount of $3,998.80 includes all of it. It also includes $341.80 of court fees, the filing fee of $130, the court mailing fee of $26, service fees of $110.80, and a statutory attorney fee of $75.
All right, so how much are court costs?
Court costs are $341.80.
All right. That's included in the $3,998.
And 80 cents, yes.
Yes, okay.
All right. And the parties have agreed that part of this is Enchanted Glen will participate with any third-party agency that payment assistance may come from. There are some technical issues that Enchanted Glen may have with working with certain third-party agencies. We will still agree to participate and cooperate fully. The tenants will hopefully advise us of their efforts early on, so contact can be made with the third-party agency to troubleshoot any of those technical issues as to acceptance of payment or payment processing. There's also a condition that Ms. Bauer can explain in more detail, because I don't want to misstate the terminology, but there is a counseling component. These tenants have had some other issues that are outside of the non-payment that have been discussed loosely by Ms. Bauer and I throughout the pendency of the action. And one way to help these parties reach a global resolution, there is an agreement, I believe, by these tenants to participate in some counseling, and then as a condition, if they enroll and participate, the previous violations will be waived, not waiving future violations, but at least it helps the parties with a fresh start. And Ms. Bauer, hopefully you can chime in and clarify where I may have confused things.
I think that actually does reflect what we've said, what the parties have agreed to pretty well. I could break those numbers down differently for you, Judge, based on rent, court costs, and late fees, but I fear putting additional numbers out there may be confusing. As my colleague has
Now,
stated.
one of the concerns, I'm sorry to cut you off, that you had was you didn't want to, the funding agencies didn't want to pay their rent and then find out they were going to get evicted anyway for other past alleged grievances. So this counseling component would waive all past grievances. And as Mr. Popovich said, start with a clean slate in January, so they can get their rent paid, get some financial assistance, and start with their rent being $5.99 per month this month and next month. Mr. English, did you hear everything that was said? You need to unmute your mic.
Yes, I did. Yep.
And the 2 defendants are together, Judge.
Yeah.
Oh, you're now muted though, Judge. Gary, can you hear Judge?
No, I cannot.
I can't hear him either, no.
It says he's muted.
Sorry, Judge, I couldn't read your lips on that one. The good news is I have 98% of this drafted in a stipulated order that will have myself and Attorney Popovitz and the defendant's signatures on it.
I came in very early this morning.
We can hear you
And
now.
when I do that, it kicks me out after 8 hours. So if I don't catch it, it turns me off. Got here about 10 after 7 to get ready for the day, which has been a long day. When I kicked him off, I hope he understood I wanted him to come back. So.
Is that Ms. Bauer's clients? It looks like they may have.
I believe that's the reference, yeah.
Yeah, okay.
Are they back? No, that's some small claims defendants.
Yeah, I'm getting them a message, Judge. I will have their stipulation, or their signatures on the final order, and I don't know if you caught it, but I have most of this drafted already.
All right. Let's talk to the folks from Enchanted Glen. Ms. Patterson's from the head office and Kim is here from the local office. Did you both agree to these terms and conditions?
Yeah.
Yes.
All right. The goal is to have them have a clean start and get on track for 2026. And I guess I don't disagree with any of that. Who's preparing the order?
I've got it, Judge.
All right.
I'll circulate it to make sure all the I's are dotted and the T's are crossed.
You guys did a lot of work on this. You know, it took us from September to December, but you tried to take care of pre-existing problems, work toward December and January. Now the ball's in their court. All they need to do is hold up their end of the deal and they can start with a fresh start. Not we worried about it, but if they're going to get back in other bad habits, maybe there'll be a further hearing. But we've determined the amount of money and the other terms. So it doesn't look like they're logging back in. Ms. Bauer, I'll wait the order. I'll tick a list for 10 days.
Thank you, Judge. I appreciate your accommodating us so that we could get this over the finish line here.
All right, thank you. We did manage to make it work, so there was something to be said for that. All right, thank you, Mr. Popovitz, for your hard work and everybody else. All right, we'll return back to our small claims case.
Have a good afternoon.
Thank you. It's almost over. And I can blow my nose with wild abandon once I get off the bench. All right, ladies, it's down to just us. So we heard Ms. Shelton's version of why this money is owed. Ms. Zablocki, you didn't appear because you didn't have notice. And so the default that was entered was probably entered in error, although I indicated we didn't know it. So what do you want me to know? She breaks this down month by month on how much you owe. What's your response?
I have something written down so I didn't forget what to say. I sent you that letter, and a majority of what I wanted you to hear was in that letter. Let me see.
Yes, it's dated October 13th.
Yeah, that was just me explaining my side of the situation since I didn't get to appear and do that over Zoom with you guys when the court date was here. I
Now,
didn't
you
really.
feel like she should have actually gone after Dominic Land,
Yes,
but
sir.
she doesn't have to. I guess she can pick her
No,
defendant.
no, she doesn't necessarily have to. No, she could.
Okay.
I mean, she did just, I mean, she's going after me for it, but I don't feel like it's fair, nor was there lease agreement between us. I don't have the financial needs to pay that much money. I raised 5 kids by myself with no help from fathers. Not that it's anybody else's responsibility, but it would put me and my children in very much financial debt, which is why I kind of feel like her coming after me is a little bit more personal on her emotions because the agreement, when we moved in, the agreement was with Dominic's job, and her coming after me just kind of feels more personal. Just me only.
Well, as I said, she can pursue her defendant, but why not sue Dominic if he's another source of collecting on this?
Because I didn't make any agreements with Dominic. I only talked to Kaylee.
That's false.
This Shelton, this goes under the category of no good deed goes unpunished. You took her in, they were at dire straits. You didn't have a lease. You didn't really exactly know what you were doing in the landlord-tenant business, but you tried to keep track each month of how much was due.
Yep.
Perhaps this could have been done better. Dominic was employed and responsible for paying rent. We paid rent for December, then he lost his job. They didn't pay January's rent, February's rent, March's rent. And so those figures are accurate. Now, this is a lot of rent for a basement. Probably not code compliant, but nonetheless, describe this house to me, Miss Shelton. What is it?
The 4-bedroom, 3-bathroom.
And which part of the
finished.
house? They rented the whole house?
No. They did the basement. I offered the bedrooms upstairs, but the kids ruined like my closet door, a bunch of different things. So they stayed in the basement.
And what was down there?
It's like 3 rooms. It's like half finished. The walls need just the drywall on them. The floor has flooring.
How many bedrooms?
4.
In the basement?
Oh, no, in the basement there's 3 rooms. They're not bedrooms, but there's 3 rooms.
Is there a bathroom?
It's upstairs. There's 3 bathrooms in the house.
And then what about a kitchen?
There's a kitchen.
So they had access to the bathrooms and the kitchen?
They had access to the whole house, yes.
So this really, the wheels fell off after the first month. And they did try to make some payments as they could. What happened to Dominic?
He lost his job in December, and I was freshly postpartum when we first moved in, so it wasn't as easy for me to find employment right away. When he lost his job in December, I was able to receive employment and paid Madison what I could. Dominic and I were going through issues in our relationship, and we ended up breaking it off officially in March.
Okay, so he's not in the picture anymore?
No, he has not been at all, for almost a year. No, since March, sorry.
All right. Well, it's, one thing is owing something, another is being able to collect on it. But I think this money is owed. Whether it's fair that they went only against you, I don't know, but we're talking about January's rent, February's rent, March's rent, utilities.
I do have a question for you though, because by no means did the agreement of utilities ever come up, not with me, not with Dominic. The agreement was made with Dominic because he was the one that was employed to pay half of the rent. And the utilities are just being tacked on. That was never, when me and Matt, right before I had moved out, Madison had asked me if I could help with utilities. And I had explained to her that I was giving her what I could because I was paying $250 in childcare on top of giving her what I could. Didn't have any kind of state assistance or child support to help feed my kids. My daughter was living off of $50 cans of formula every 3, 4, or 5 days, depending how much she chose to eat. Like I was really struggling financially, especially mentally. And I just wanted to be able to, it was my kids over anything else. And I'm sure anybody who's a parent can understand that. But the
Well, do you
utilities
agree that the
never-
rental amount was $1,200 a month?
Yeah, that's what they had agreed upon, was $1,200 a month.
And was there a clause for you would pay half of the utilities?
No, there was not.
The deal with the utilities was when she moved in November, she had food stamps and she was getting about $1,700 in food stamps. And I said she didn't have to pay utilities if the food went into the house for everybody. In December, her food stamps got cut off. And at that point, I told her, okay, well, if you're not helping put the food in the house, I need help with the utilities now. And then she didn't have food stamps the rest
There's a way
of the
that you
time.
do that, Ms. Shelton. It's called a lease.
Yeah.
You're changing the rules in the middle of the game. I think everybody's on the same page that rent is $1,200 a month. So we've got 4 months, December, January, February, and March. So
I'm
there's
sorry,
40.
Your Honor. Can I say something really quickly?
Yes,
December, January, and you said December, January, February, and March. Those are the months that we did not pay at all.
yes.
Okay.
Well, I'm gonna offset it by the amount you paid. The total amount of rent for those 4 months was $4,800. So let's figure out how much you paid. Paid $300 in December. You paid $200 in January. You paid $600 in January. March rent paid. Did she pay March's rent?
Yes.
No.
Or I thought she did. If I wrote it down that she did, she paid it.
All right, then she owes $3,600. So I'm gonna subtract what she did pay, which was $1,100. Let's recap that. It appears that she paid $300 in December, $200 in January. She paid $600 in January. And I took March out of it. So 3,600 minus 1,100 is $2,500.
I'd also like to add that I didn't include the trash removal fees, also the damages to my house from her and her children. We had to load up 4 trucks of garbage and take it to the dump.
Yeah, I repeat what I said. No good deed goes unpunished. You don't have a lease. You're doing this on a handshake and a he said, she said.
Correct.
And so my advice is don't get in the landlord business like this again. And it's probably not code compliant. If this was in the city of Constantine or 3 Rivers, you couldn't rent it like this. You couldn't charge somebody $1,200 to live in your basement. So I find $2,500 for the plaintiff, plus the court costs, of $86.25. Total is $2,586.25. Miss Shelton, Ms. Zablocki, I don't believe you presently have the ability to pay anything on this. You got 5 children and no child support help.
I make $13 an hour, Your Honor.
You're just barely keeping your head above water, but
I don't even
nonetheless,
think I'm above water.
this was a debt that was incurred. I took all the utilities and other expenses out of it. I gave you credit for everything that's been paid. So the motion to set aside, the default was set aside for lack of service. And we'll do a new judgment of $2,500 plus costs. Ms. Shelton, you're still on Michigan Avenue.
Yes,
Is that where this house was?
yes.
Well, you can't do that in the city of Three Rivers. 318 East Michigan. Is that the big house that Dave Miller used to own?
I don't know a Dave Miller.
Is it kitty corner from Riverside Church?
No.
I'm trying to figure out, I'll look it up. At any rate, yeah, this wasn't code compliant with the city of Three Rivers. Ms. Zablocki, is your union address presently correct?
No, Your Honor.
I'm going to shut off the live stream and have you give me your address.